Hello, and thank you for joining us for the third episode of the Practical Patent webinar series. This episode will discuss docketing final office actions, appeals, allowances, and issuance. This is the third episode in a four-part series. The final episode will be coming up in October. A recording of the webinar and the slides will be made available to all registrants. Feel free to enter any questions using the Q&A feature in the Zoom menu. They will be addressed in a Q&A session at the end of the webinar. We invite you to follow Black Hills IP and Schwegman, Lundberg, and Wissner on LinkedIn to see news about other upcoming webinars. And with that, I'll turn things over to our moderator.
Great, thank you. Hello, everybody, and thank you for joining our program today. I'm Ann McCrackin. I'm the president of Black Hills IP, a patent attorney, and also an adjunct law professor. And today we're going to be talking about docketing, final office actions, appeals, allowances, and issuances. With me, I have Zhakalazky Carrion. She's the docketing manager at Schwegman, Lundberg, and Wissner, which is a pretty big job at a pretty big firm. And then Adam Reece. Adam is an IP automation specialist at Black Hills. You might not know what an automation specialist is, but the future of legal operations is going to have automation specialists like Adam, who work in law firms and corporate legal departments to help speed up operations. Docketing automation specifically is a career path that people are starting to get into. And at Black Hills, we have a large automation team, and we'll be getting some insights from Adam that reflect a little bit of what he does as part of his role as an automation specialist. So thank you both for joining me today. Looking forward to talking through things with you. Michelle, let's go to the next slide. I'd like to launch a couple of polling questions to just get a sense of who is in the audience today, what level of background, and what type of docketing systems they're using. So the first question is, what is your primary role in your organization? If everybody could just quickly indicate if you're a docketer, a paralegal, attorney, a manager or administrator, or you're an IT or some other role. So we'll take just a few seconds to get a little bit of a picture of the audience today.
Okay, and it looks like most people have voted, so I will go ahead and end polling.
All right, so we have a third of the audience is in a docketer role, a third of the audience is in a paralegal role, a number of attorneys as well as managers or administrators, and a few people in other roles. So it's a good distribution. Michelle, let's go to the next poll. So and if it could go to the next slide too. So just to get a sense of your perspective as you come into this program, I'm curious if your US patent docketing is done by a team internal to your organization that is specialized in just docketing, so you've got a very focused team, or if you have your paralegals also do the docketing, or in some cases, I know some people use outside vendors, or maybe you're in-house and your outside counsel is responsible for updating your docketing system, or some smaller practitioners don't have an internal docket at all, or something else. So let's just take a few more seconds and respond to the pop-up menu or window with the choices and see what we have going on for different scenarios with respect to who does your US patent docketing.
And it looks like most people have voted, so I will go ahead and end polling.
Great. Okay, half the audience has their own dedicated docketing team, and then another quarter of the audience has the docketing performed by their paralegals. So that's 75%. There's a small group that has an outside vendor do the work, an even smaller group that has their outside counsel update their docketing systems. So those would be corporations, and then a couple people in the other category. Good. All right, one final question that I always find interesting, and that is, what docketing system are you using? So Michelle, let's launch the poll and go to the next slide. So are you using, and I know there's more systems out there than just what we have on this list, but the webinar tool that we're using limits the number of question or options you can have for choices. So if you're using something other than what we have listed here, which is a NACWA app call, CPI, Foundation IP, ImperTech, IP Folio, IP Manager, Memotech, or Patricia, or other. If it's other, why don't you put in the chat window what the system is, because I'm curious what, those are some of the major systems, but what other systems people might be using if it's not one that's on our list.
And it looks like most people have voted. So I will go ahead and end polling.
Okay, interesting. The most common system with this audience is CPI, and then it looks like it's a close tie for second between Foundation IP, which is slightly more than a NACWA, with a couple of app call users, a couple of people using IP Manager, and then some Memotech users. And let me see. I'm seeing some perfect law. Yeah, I wish I had another spot on the list, because that is a common one that we're seeing, and I just didn't have enough choices that I could put that in the poll. Some people that are changing. Okay, good. That's just helpful to know what systems people are using. All right, Michelle, let's go to the next slide. All right, our objectives today are for you, by the end of the program, to be able to identify common patent office, US Patent Office documents, including final office actions, pre-appeal and appeal documents, and allowance and allowability documents. We also, it's also our objective to help you understand what the deadlines are that need to be docketed for these documents. And then finally, we're going to discuss some about how automated docketing software can help reduce the manual docketing errors associated with these types of documents. Now, I've designed this program so I hope that it has a little something for everyone, regardless of your level of experience. And I know we have probably wide ranges of experience in the audience. So if you're new to US docketing, the objectives number 1 and number 2 are for you. We're including images of each of the documents for your later reference. Those images have a lot of stuff on them, and we're not going to go through everything on those documents, but you will have these slides made available to you. We'll provide them after the program so that you can download them and you can have those for reference. If you're more experienced, or if you're a manager or somebody who's responsible for docketing operations, I think you'll find the discussions about automation interesting, and just some of the complex documents that we're going to get into as well will be helpful for you. So one of the things that I think is the most difficult part of the docketing process for humans is to identify documents correctly. This is where mistakes often happen. And people sometimes ask me how a machine, because well, Black Hills is in the business of automating docketing, people sometimes ask me how a machine can identify documents that are so nuanced. And my response to that is, that's exactly why you want a computer to do this type of work instead of a person. And we're going to give examples as we go through this program where you'll see some of the things that actually can be done much better with a machine because it's more reliable when it comes to identifying the type of document that's being processed than what a person can do. So just a little heads up, those are some of the things we're going to be talking about today. Michelle, let's go to the next slide. And if you're newer to IP or to docketing, just to give you a little bit of context where we are in the overall process, we have had two prior webinars that focused on the application filings and the earlier parts of the examination process. Today's webinar is focusing pretty much on the middle and later stages of the examination process. And our fourth webinar in this series will cover docketing after the patent issues. So next slide. So today specifically, we're covering 3 categories of U.S. prosecution documents. Final rejections and advisory actions I'm lumping as one category. Appeal-related documents is a second category, and allowance and issuance is the third. Like I said, we'll show you real documents in each category. These documents that we are presenting are from published applications, so there's nothing confidential. These are all publicly available, but we've still redacted or replaced any identifying information. We're not going to go into great detail on the documents other than the key things that are related to identifying the deadline in these documents, but you will have them available in the slides to you later for your later reference. All right, next slide, Michelle. All right, final rejections and advisory actions is the first category. So let's just jump into it. I'm going to hand this over to Z to start us off.
Well, hello, Anne. So we're seeing in front of you guys a final office action. And for the purposes of not providing all of the final office action, we're going to be seeing the main 2 pages of where's the information that we need to look for, what's going to determine my my deadline or my due dates. The first page is that cover sheet, and that's where we see the mail date of the final office action received. The second page, where is the office action summary, is where it is indicated the deadline, the due date, and the extensions of times that we have, and identifying what kind of action it is. And I'm going to ask Adam. Adam, how does that automated docketing software know if this is a final office action or an office action?
So the software would look at a variety of different places. We'd look at the check boxes to see what's been checked. We'd look at the body of the action to see if there's language indicating the response is final. And we'd look at the pair label as another indicator.
So your system would be able to see that box 2A was boxed up.
Correct.
Cool. And so once we know that this is a final office action, we know there's a language in the document. Let's go to the next slide. And it indicates to us that we have 3 months from the notification of this office action received, and that it's extendable for 3 months. And if you see when it's mentioning the deadlines, we only have 6 months to be able to respond to this action. Let's go to the next.
All right, so Michelle, this is a poll. Can you launch the poll? I just want to take a quick poll here because Z just told us that the Patent Office deadline for responding to a final rejection is a 3-month deadline extendable up to 6 months. But I know that it's common practice for many organizations to docket a 2-month deadline for responding to the final rejection. So I want to see how many organizations do that. So let's just take a second and indicate if you do docket a 2-month deadline for responding to final rejections.
And it looks like most people have voted, so I will go ahead and end polling.
All right, so the majority do docket a 2-month deadline. 82% are docketing a 2-month deadline, although there's a good number that aren't. So Michelle, let's go to the next question, because I want to talk about why do most people docket a 2-month deadline, even though there's no indication of that on that office action summary page that we were looking at. So yeah, so the reason for doing this is because if you respond to a final rejection, this only applies to final, not non-final. If you respond to a final rejection within 2 months of the mailing date of the final rejection, and the Patent Office will issue an advisory action, and if that advisory action is not mailed until after the 3-month shortened statutory period, then you don't have to pay, well, then the shortened statutory period will be basically extended to the mailing date of the advisory action. And the extension fees for responding are calculated then from the advisory action, not from the original 3-month date. So let me back off and break that down a little bit. First of all, what are we talking about with the shortened statutory period? Well, the shortened statutory period is the period that the applicant has to respond to something without paying an extension fee. So in this case, what happens is with that advisory action, the Patent Office will give you a longer period than the period indicated on the document. They'll give you until the date of the advisory action being mailed to respond without paying an extension fee. Now, most attorneys want that because it gives them a little bit more time. It gets them the useful information of having the information that comes in the advisory action available when they're making their next decision. And because of that, typically organizations will docket that 2-month deadline, so it's on the attorney's docket so that they file that response at that point and they get the benefit of this rule. Now, this comes from language that is typically in the text of the office action, not on that summary page with the checkboxes that we were looking at. And I pulled a typical form paragraph that you generally see at the end of the office action. If you're wondering where this comes from, that's language right out of an office action. So knowing that there's some advantages to watching for your advisory actions and then responding after you get that advisory action, I know we're often asked if we can prioritize docketing advisory actions or if we can notify people that an advisory action has come in. So Adam, can you talk a little bit about what automation can do to help with requests like that, where there's a document like this that's a high priority one for an organization?
Yeah, so automation can quickly identify an advisory action that's come in, and once that identification happens, you can do a number of things with it, whether that's placing it at the top of a docketing queue, having a process in place to notify people who need to be notified. Black Hills even has a docketing portal that can display these sort of things.
Okay, so I want to talk a little bit about advisory actions, but before we do that, Z, is there anything else we should discuss about final rejections before we go and look at an advisory action?
I have a warning for people. So let's go to that next slide and I'll give you a couple of tips. So don't think that because you already responded to your final office action that you're done. To avoid any type of abandonment, you must make sure that you docket a notice of appeal or an RCE at that 6-month deadline, because don't think that just because the response after final, it's going to stop your clock and you're all good to go. So one of the key points that I would suggest as a docketer is okay, something still needs to be in your docket. And what is that? You docket an RCE or a notice of appeal. In our case, we always make sure that we docket a 6-month deadline of a notice of appeal. It's one or the other. It doesn't mean that you must file a notice of appeal. If you want to do the RCE, you can totally do that as well. But I would suggest always keep something docketed for that 6-month deadline.
Great, thanks,
So-
Z. And I'm not sure if this is just me, but I'm not seeing all the text on this slide. Z, are you seeing all of it?
No, I just see RCE.
Yeah, Michelle, let's go to the next slide and just make sure that everything's coming through.
Oh, there it is.
There you go, we got it. Okay.
Surprise, this is the response.
Good. So this is another spot that I find interesting because practices vary about how people docket or what people docket to keep a 6-month deadline out there. And I don't want to do a polling question, but I'd love if anybody wanted to share in the chat what your practice is. Do you keep a notice of appeal on the docket after that response is filed, or do you docket an RCE? Do you docket both? Because I think it would be, people would be interested in seeing the varying practices. I always find this interesting. So if anybody wants to share their practice in the chat window for everybody else, that would be great. All right, let's go on to advisory actions. So Michelle, let's get the next slide up. And before Z jumps in, basically an advisory action is a form that you can see looks a lot like an office action summary sheet on the right here. And the advisory action notifies the attorney of the status of any amendments that were submitted with the response to the final rejection and the result of their arguments, whether they were entered or not. And then the attorney will use this to make a decision on next steps. Do I appeal? Do I file an RCE? Do I abandon it? What do I do? So Michelle, I'm sorry, Z, let's walk through this one.
So we're seeing an advisory action, and we're seeing that this has a little box where it says before the filing of an appeal brief. And what does that mean? Well, exactly what it says in that box. This is an advisory action that we received before an appeal brief was filed. So let's say a final office action got responded to, and then we end up getting an advisory action. So we will, some systems will docket based off of the mail date of this advisory action received or based off of the final office action received. Now, I am intrigued, Adam, what does automation look into when they get the advisory action? Because there's a tons of boxes here. So what does your program identify to say, this is what I need to docket?
So automation will look at what kind of advisory action is. So like there's that box highlighted before the filing of an appeal brief. We want to know if that's the case. And then we also want to see particularly whether box 1 or 2 is checked on the form, because that can affect how we docket it, as well as those boxes A, B, and C under 1 to see some additional details that can be used in docketing.
Okay. And this is actually very helpful because then you know if at this point you need to docket a deadline or not. So let's go to the next slide. For this particular advisory action, there is a deadline that needs to be docketed. It needs to be based off of the mail date of the advisory action or the date that is set forth in the final rejection. But no matter what way or route you end up going, you need to make sure that it's 6 months from the mailing date of the final rejection when you're responding to this. So let's go to the next one. So in the previous slide, we talked about before the filing of an appeal brief. This one is an advisory action that is received after an appeal brief has been filed or a notice of appeal has been filed. And in this case, we wouldn't docket a deadline. What is it that you see in this one, Adam? Like, would you docket a due date if you would see that it's an advisory action after the filing of an appeal brief?
No, automation would, see that it's after the filing of the appeal brief and essentially put it through a different process where, depending on the docketing system and the needs of the customer, we docket a historical action or nothing at all.
So here in this advisory action, we wouldn't docket an additional deadline. And the reason why you wouldn't docket that, it's because you already have your appeal brief that is out there because you filed your notice of appeal. So your appeal brief deadlines or due dates are out there, or they should be docketed in your system. So let's go to the next. So yeah, in this case, no deadline needs to be docketed for this one. And the language of the document is just going to vary depending on what is checked on box 1 through 4 of the document. Sometimes it's just saying, well, we ended up accepting your office action response, or the notice of appeal was filed on this date. So let's go to the next.
Yeah, and before we jump into appeals, I just want to comment on what's striking to me listening to Z and Adam talk. And that is, with these final rejections and appeals, there's a number of different scenarios. You have a single document, either a final rejection document or a advisory action document, but in the context of either one of those, a single document can have a lot of variations on what needs to be docketed depending on what boxes are checked. So essentially what the context is. And that can be easy for a person to overlook a box on one of these forms. And that's where I really see the advantage to having a machine looking at these forms, because a machine's always going to read the same thing, read the whole form every time, and it's not going to miss a box and overlook something that needs to be docketed. So that was very striking looking at those examples that the two of you presented. Let's move on to appeals now. I got to say, the US appeal process can be confusing, working through the options at the PTAB, particularly because you have a number of optional procedures. You may or may not have a pre-appeal brief. You may or may not request an oral hearing, for example. And so Z's got a great way of making all of this a little clearer through a visual form. So Z, can you walk us through this workflow diagram that you've prepared, just to give us an overview and set the stage to talk about docketing appeals?
So just want to give you a little heads up. The boxes that are in gray are documents that we are receiving from the PTO, and the boxes that are in blue are actions that an applicant can take. Okay, so we're here with the final office action. You have the opportunity to respond. You already know that you docket your 2 or 3 month deadline and your 6 month deadline. That is a notice of appeal or an RCE, depending which route you're going to go. So let's say that you go through the route of the notice of appeal. Let's make it a little complicated. Let's do the notice of appeal. At the same time, you're going to file that pre-appeal brief due. And if you file that pre-appeal brief due, what is it that you're going to expect next? A decision on pre-appeal brief. So let's say you don't file that pre-appeal brief, you just file the notice of appeal. Then in appeal, you have 2 months from when that notice of appeal was filed to file an appeal brief. Okay, well, here you are found in a special little area, because let's say you file your pre-appeal brief and you end up getting your decision on pre-appeal brief. Well, once you get that decision, you have 1 month to be able to reply to that pre-appeal brief, or you actually have 2 months from the notice of appeal that it got filed. So you actually have the opportunity to pick which one of these due dates is the most convenient for you, and in which one you're going to avoid extensions of time. So because sometimes that decision can come a little later than that notice of appeal filed, and then you're like, well, I don't have to file an extension of time anymore because my decision just arrived and I have a month from that decision received. So you get to choose which one is best for you. Okay, let's say you docket the later one of the two appeal briefs, and now you file it. Now what you're waiting for is an examiner's answer. And we just wish that all this came really like month after month, and within 6 months you're going to be done. No, it takes some time. So you get your examiner's answer. And once you have this examiner answer, you have the opportunity to request to reopen prosecution, or for you to reply to this examiner's answer. And you have two options, okay? You have the option to reply to the examiner's answer, or request for oral hearing and fee due. What you don't have an option to do, and please, this is very important, you have to pay an appeal brief forwarding fee. This is a 2-month deadline for these optional responses, and for this absolute final deadline or requirement. But no matter if you don't want to respond to the examiner's answer, you must file an appeal brief if you're not going to request to reopen prosecution for this matter. So, okay, we go to the site of responding to the examiner's answer. Then months later, you end up getting a patent trial and appeal board docketing notice. What is this? This is a document where the PTO is telling you your appeal number, and now you just wait, right? You wait for the appeal decision received. And what is this? It's a document where the examiner is going to tell you what's up with your appeal. Did they reversed your claims? Did they affirmed in part your claims? And if you get a decision of appeal that is reversed, you just sit down and wait for your next action to be received. But if it's affirmed in part, or a little tricky, reverse with rejections, you end up getting, you need to respond to it and do an appeal to the CAFC, request rehearing, or reopen prosecution. And here you have 2 months, again, 2 months deadline to respond to this appeal decision received. And we'll be seeing examples in future slides. Next slide.
Okay, so it's complicated, right? And I know that chart's kind of hard to read. You'll be getting the slides, so you'll be able to look at it and blow it up so it's a little easier. It's always a tough choice with that chart, whether you split it up over 2 slides so it's easier to read, or you put it on a single slide. And I think to walk through it works a little bit better to have it all on a single slide. So I apologize for the text being kind of hard to read. Before we look at examples of those documents, which we're going to, I want to just lay out the big picture from a docketing standpoint and give some tips and suggestions, because this is a complex process. Your approach to docketing these various items may vary, but here's a suggested practice that that we recommend. If you start with the docketing of the notice of appeal due, we talked about that, and I saw several examples where people say that is what they docket when they have the final rejection, to keep a 6-month date out there. Docket notice of appeal due 6 months from the final rejection. Then after the notice of appeal is filed, you would docket an appeal brief due 2 months from that notice of appeal being filed. Now, this is not necessary, but some people will put a item on the docket like examiner's answer expected 2 months out from the filing of the appeal brief. That's kind of like a status check. Again, really not necessary, but there is common practice of doing that. And then getting back to the hard actual patent office deadlines, when you get the examiner's answer, very, very important, and that you have a 2-month deadline docketed for the appeal forwarding fee and the reply brief. Then again, another common practice, not really necessary. You might also put a appeal decision received action on the docket. And then finally, another very important item to be sure you have on the docket is after you get that appeal decision, depending on what that decision is, and we'll go through this in detail, you may need to have a 2-month deadline for an appeal to the CFC or requesting a rehearing or reopening prosecution. So that's big picture view. Now we're going to look at specific documents and these individual deadlines in the context of a specific document. So Z, let's go to the next slide, Michelle. And Z, can you walk us through these appeal documents?
This is an example of a notice of appeal filed with the pre-appeal brief. This is the document that you're going to get after you file that pre-appeal brief, and it's a decision. And in this case, you would be, let's go to the next slide. In this document, there is a deadline that needs to be docketed. Like I mentioned before, it's going to be 1 month from the decision or 2 months from the notice of appeal, and it's extendable for 5 months. So we even see this in the body of the email of the document, that it gives you the option of responding to this decision to be 1 month from the mailing of this decision, or the balance of 2 months time period running from the receipt of the notice of appeal, and whichever is greater. So here you get a little option to pick of which route you're going to go. Let's go to the next one.
Actually, Z, let me jump in before you go to the examiner's answer. And if we can go back, yes, to this pre-appeal decision. From a docketing standpoint, this is one of the things that I think is tricky with respect to appeals, because this is kind of an either or scenario. So you can get the 1 month from the decision or 2 months from the notice of appeal. And that's, again, where I'm wondering, Adam, if automation can help us in this situation. When we get a pre-appeal brief decision, what kinds of things is the machine looking for?
So the machine will look to identify the document. But then in these kind of complex scenarios of which date should be launched, automation can help put it down a pathway for whatever scenario applies. And then it's kind of dependent on the docketing system, how that would be entered. But there's ways to identify, here's the scenario. And once you get to that point, what you do should be apparent in your system.
Okay, good. That's helpful. All right, Z, keep going.
Well, let's go to the examiner's answer, because if you thought it was complicated, now I got some stuff for you guys. So we're at the examiner's answer. We've been waiting for this. It's very obvious that you got the examiner's answer, because in the second page of the document received, it's there. Let's go to the next slide. When we get this, this is where I was telling you that you have the opportunity to reopen prosecution or respond to the examiner's answer. But in the last part of this document received, there's always a last note from the PTO, because I'm guessing there's a lot of people that just kind of forget that if they don't want to respond to it, that there's nothing else for them to do. And there is. If you want to proceed, you must pay that appeal forwarding fee that I had mentioned to you earlier. So even the PTO points it out as a little tip. Let's go to the next slide. As a tip for us at Schwegman, activity or this action to take is important because your matter could go abandoned if you don't pay for this appeal forwarding fee. We add a note to the activity saying this is a must requirement. So it is not extendable, and you only have 2 months from when that examiner's answer was mailed. So in the body of that examiner's answer, it says, in order to avoid dismissal of the instant appeal in any application or ex parte reexamination, it requires the payment of an appeal forwarding fee. So let's go to, okay, no, let's just stay here a little bit. I want to make sure that when you are docketing these activities, make sure that you do it separate, because if you're not going to respond to the, you're not going to do a request for oral hearing, or you're not going to do a reply brief, which are optional, you know that for sure you must pay that appeal forwarding fee. Let's go to the next slide.
And I'll jump in, Z. So back on the examiner's answer, actually, this is another spot where I often see humans make mistakes, because it's another point in the process where there's some things that are optional and some things that are required. So again, you got to be really careful making sure that you have processes in place that are identifying the things that are required, and that appeal forwarding fee is critical to make sure it's docketed. Now, moving on to the next thing that you would typically see is the appeal docketing notice. Now, this one's an easy one. There's really nothing to do here other than from a docketing standpoint, there's no deadline to be tracked. There's no response required to this document, but there is useful information that comes on this document. And we have that noted on the second page where we've highlighted the appeal number. And that appeal number is something that you oftentimes will have tracked in your docketing system. So let's go to the next slide. So with respect to this appeal docketing notice, there are no PTO deadlines, though, that have to be added when you receive this particular document. So we've been talking about what automation does with all of these complex document scenarios, but what happens when something comes in and there's nothing to docket? Does that even go through automation, Adam?
Yes, it still would. So automation can still help in a few ways. There's the classification aspect of here's what we're looking at, and then the follow-up to that is how do we docket it, or do we docket anything at all? That's going to vary depending on the organization. And it can also pull data that's relevant off the document. Say, for some reason, you need to get this appeal number entered. We can pull that off the document and enter it into your system.
Okay, good. All right, now the lead up to the different types of decisions that you could get on your appeal we're finally here. So Z, can you walk us through the decisions on appeal?
Yes. So for visual people out there like I am, we wanted to provide examples of the variety of decisions on appeal that you might receive in an application, but sorry, for timing purposes, I need to quickly swift by the examples, and I'll point out where to look at to identify which kind of decision on appeal was received. We already noted it was the reverse with new grounds of rejection, affirmed in part, and affirmed. This one that we're seeing in front of us is a reverse. And this is, we're seeing the first and second page, and usually in the conclusion, which would be the second to last or the last page of the decision, is where you see that it was reversed. So what we're seeing right now, this one's a reverse. Let's go to the next slide. And usually it's been really nice. The patent office has been providing like a little summary box of the claims, and it's telling you if it was affirmed or reversed. Here in the conclusion, where it's noted that it was reversed, and all of the claims we see that they're all reversed. There's nothing in affirmed. Check what we do. What do? We just wait for another action to be received. Let's go to the next slide. This one gets a little tricky because it says reverse. You're like, oh, we're good, we are in the clear. But if you're not paying attention, sometimes it comes with a new ground of rejections. And sometimes this ground of rejection is not noted in the very first page. So let's just go to the next slide. And if you see here, if you would just see the conclusion, it says it's reversed. It's not telling you that new grounds of rejections are needed, yet it does mention in the documents that you receive for this decision on appeal that you have the opportunity, you have 2 months to file a request rehearing or reopen prosecution for this application. So I am intrigued, Adam, does the automated docketing software identify that it's not just an appeal that is reversed, but it also has new grounds of rejections and that something needs to be docketed?
Yes, so automation can look for both, what the decision is, reversed, affirmed, whatever it may be, as well as looking through the document for anything that would indicate new grounds of rejection. So with both those parts, we can make the determination of how to docket it.
So let me jump in, Adam. We keep talking about looking for in the document, text in the document, or looking for something in the document. What is it that enables us to be able to do it? There's a preliminary process that OCRs these documents, right?
Yes, so most of these documents come in the form of PDFs. You need to have text to actually read through it as a computer. So an OCR process will take the PDF and apply a text layer so that we can do that. And then it's a matter of looking for words or phrases that uniquely identify the document. And various combinations will apply depending on the document. And sometimes there's even things you don't want to find in order to make a determination.
Oh, you're looking for the absence of something. That's
Yes.
Interesting. Very interesting. So it's essentially the machine is reading the document. It's looking at the text in the same manner that a human would be reading the document, looking for certain words, phrases, or like you said, the absence of certain language too. But it really is reading the document in that sense, right?
Yes, that's correct.
It's pretty cool. Okay, sorry, go ahead, Z.
Well, then I guess this just makes it easy peasy for automation for the next slide that we're going to see. The decision on appeal affirmed in part, because here it's not just saying reverse and having actually new grounds of rejections. It actually has, it's very specific. It's affirmed. And when you get an appeal that is affirmed or affirmed in part, we know that we need to docket something. So you see in this document, this is again the first cover sheet and then the last part, like the conclusion. And if you see in this conclusion, it has the box where it says what claims were affirmed, which ones were reversed, and the new grounds of rejections. At this point, the time period for response is being very specific in saying within 2 months from the date of this decision. So when we get this affirmed in part and it's giving you a 2-month deadline, I see that somebody mentioned that we have 63 days. And yes, that is accurate according to 37 CFR 90.3 time for appeal. But if you're seeing this decision on appeal and it's giving you 2 months to docket the deadline, I think I would feel a little bit more comfortable going ahead and docketing those 2-month deadline, the 2-month deadline rather than the 63 days. So anyways, let's move on to the next slide. This is a decision of on appeal that is affirmed. And if you see in the conclusion part, we have a box where it's telling us that all of our claims were affirmed and none were reversed. And then you end up docketing your your time responses. Please note again that it's being very specific, that there is no extensions of time available. So you only have these 2 months to be able to reply. So I know these appeals with all of these dates, it makes it confusing. Let's go to the next slide. And I think this is yours, Ann.
Yep, so it is confusing. It's the typical answer, is there a deadline to docket? Well, it depends. It depends on the decision. So when the examiner is reversed, then there's no deadline for you to docket. You're basically going to just wait for the next office action, because that's going to go back to the examiner to look at the case again, because his rejections have been reversed. However, if there is a new grounds of rejection, so reversed with new grounds of rejection, then you need to docket a 2-month deadline that is non-extendable. Or if it's affirmed in part or affirmed, in all 3 of those cases, reversed with new grounds, affirmed in part, or affirmed, you need to docket the 2-month deadline. And that is really important, because that is not extendable. So, you know, one of the things that strikes me here about appeals, and in comparison to the first section where we looked at the final rejections and the advisory actions, is the lack of structure in these documents. Looking at this from a automation standpoint, or not even from an automation standpoint, just from the perspective of a docketer, these documents are not as standardized. With the office action, you have the check boxes, you have the forms, and they look the same every time, other than what box is checked. In this case, that example of that you guys had of the reversed with a new grounds of rejection versus just being reversed was a great example, because if you started your process in both cases by flipping to the last page of the document and you saw it was reversed, how do you know in one that you need to go back a couple of pages and look for that language, new ground of rejection, and the other one you don't? That's very hard, because these documents aren't standardized. And we're only showing you the first and last page of these documents. These are 10, 15 page documents that are all text. So what I find striking about these is, for a docketer for a person to get these correct, you really have to have a great level of attention to detail to pick out the information that you need to pick out. And that's where I think there's a huge advantage to being able to have a machine read these documents the way Adam just explained, because if that phrase, new ground of rejection, is buried in that document somewhere, the machine's going to find it, even though a person might overlook it. So I think that's really interesting when we look at this category of documents. Now let's move on to the next section, which is allowance and issuance. So this particular category of documents also can be tricky. Now, the normal flow here for prosecution is you eventually get a notice of allowance on your application, then you docket an issue fee payment due, that issue fee is paid, then you docket an issue notification received, or maybe you docket that, maybe you don't, but you will get one and you're going to process that. So that's the way it normally happens, but in real life, not everything happens the way you would expect it to. So these get tricky because you can have a lot of different variations on these documents, and Z's going to walk us through some of those. So Z, I'll hand it over to you.
So next slide, just so we see a little standard notice of allowance. We're all happy that we got this. We're close to paying the issue fee and hopefully getting an issue notification letting us know that we're going to get a notice, original letters patent. So we get this notice of allowance. We have our mail date here, and we get the notice of allowability. And this document is very important to look at because it checks off stuff that is needed. So it tells you that you have 3 months from the mail date to be able to pay your issue fee. So let's go to the next one. This one is a notice of allowance and there's something that is due. You have your notice of allowability, and it has it's requesting for something. So in this case, it's saying that notice requiring inventors or oath or declaration, and the deadline is going to be the same as when you pay your issue fee. You must respond and file this as well. Now, Adam, I see in this example, in the notice of allowability, box 7 isn't attached. The notice of allowability is not telling us that a declaration is due. Is this something that the automated software would be able to catch?
Yes, it would be able to. So automation will look at the checkboxes on the allowability form, but it also look through the document for things like this notice requiring inventors oath or declaration, or other due dates that may be mentioned. It can even, in the case of oath or declaration, look to see whether a declaration has been filed in pair, to make that distinction if that's how someone wants to process it.
And something that I want to mention too, let's say you don't have the automation software, it's very important for you to look at the notice of allowability and all of the documents that you get. Sometimes you can get a notice of allowance with like 20 pages. It's important for you to look into it, because this is a clear example where the examiner is not being consistent of the boxes that they should be checking off. Sometimes you'll be able to see that corrected drawings are needed and box 5 isn't added. It's in the notice of allowance saying you got 3 months to file the corrected drawings. So it's very important for you to look at all of the package that you got of the notice of allowance to make sure that there's nothing due at the time of filing that issue fee. Next slide. So here it's just pointing out that we have 3 months and this is not extendable. So let's go to the next. This is just sorry.
Oh yeah, I was going to jump in on this one. As an attorney, I always like the weekend rule, so I want to talk about this one. Okay, so notices of allowance are interesting because, again, thinking about this from the perspective of a docketer, there are very few documents from the U.S. Patent Office that actually tell you the due date. Most documents just have a mailing date, and then you rely on your docketing software to take that mailing date and calculate using the software's country law rules the due date. But the notice of allowance is one of the unique ones because they actually put on the notice of allowance the due date. Not only that, the PTO is particularly trying to be helpful because sometimes that due date falls on the weekend. And because of what I call the weekend rule, which I'll show you on the next slide, in the US, a patent office deadline for filing something that falls on the weekend can be filed on the next business day. So here, these documents can be confusing because the patent office not only gives you the due date, but it also takes into account the weekend rule. So if we look at this, and I know it's a little bit small, but you'll be able to see it in your slides when you get your slides. Here we have a notice of allowance with a mailing date of May 28th. The normal, 3-month period that Z just explained, you would docket a 3-month deadline, would fall on Saturday, August 28th. But that's not what is showing here as the due date. What is showing on this document is August 30th. The reason for the mismatch between May 28th and August 30th, which is more than 3 months, is because of the weekend rule, and August 30th is the Monday or the next business day following the date that the issue fee would have been due. So if we go to the next slide, just threw in here for you the weekend rule in case you're not familiar what it's based on or where this comes from. This is from 37 CFR 1.7, and it just indicates that, as I said, when the last day for taking an action falls on a Saturday, Sunday, or federal holiday, that action may be taken on the next business day. So that's the weekend rule. Okay, next slide. Z, can you walk us through what happens when you get a corrected notice of allowance?
Pretty much, you just you're gonna restart your deadline of when this notice of allowance was received, and the examiner sends it as a corrected. And this second box that you're seeing, it says that the time period for payment of the issue fee set forth, the previous notice of allowance and fee due, is being restarted to run 3 months. This means that that old notice of allowance that you received, it's no longer applicable, that due date. You're going to go according to the date mailed of this new notice of allowance. Let's go to the next slide.
Okay, so I just want to talk briefly about quick path IDS statements, and Z's going to explain how that comes into play with notices of allowability. If you're not familiar with this program, this is a great program. It's been around for many years as a pilot program, but was just made permanent not too long ago. And this is part of the Patent Office's ongoing efforts to reduce the pendency of applications. It's a process that allows you to file an IDS after you have an allowance and you've paid your issue fee without having to file an RCE. So if you want more details on it, I've got links in the slides where you can read about it. Again, it's a really, really beneficial program. If you haven't taken advantage of it and you find yourself in that situation where you've got an issue fee paid and suddenly you discover art that needed to be cited, this is a great option. Z, let's talk about how this impacts, though, docketing of the allowance and issuance process.
So Cupids, oh my God, it always makes me think of the little Valentine's Day, and it's not, right? It's definitely not. This is a special program that the PTO created. We can go to that next slide. Let's just not get it confused with the little angel with the arrow. You know who I'm talking about. Anyways, this Cupid's program is, you get a notice of allowance, you pay your issue fee, and you realize, oh my God, I got some references that I need to submit. And so you end up submitting in RCE, you do a certification and request for consideration of an information disclosure statement filed, and then do, this is a document that it's based off of the payment of the issue fee, that it was after it had been made. This form that you would submit is PTO SB09. You have to submit your IDS and the petition to withdraw an application from issue after the payment of the issue fee, and then a little blurb saying that you're going to authorize the PTO to remove any fees that there might be. Immediately when you file this Cupids with your RCE, you end up getting a decision on petition received that it's telling you that your application got withdraw from issuance. And at that point, you're in a little waiting to see if it's going to be accepted or not. And if you end up getting a notice of allowability, that's where it tells you that your IDS and your 1449 form got accepted. Make sure that you look into it to see if all of your references got accepted by the examiner. And then right after that, you just wait to receive an issued notification. Sorry, this was so quick, but I know that we're short in time and I don't want to waste your time, but this is so important, and it's great program that the PTO has.
All right, ready to go on to the next slide, Z?
Yes.
Okay, the last document we're going to touch on, and this is another easy one, and this is always good news when you get this. This is your issue notification. So when you get your issue notification, there are no deadlines associated with the issuance. There are some post-issuance deadlines that could trigger, and we'll talk about those in our next webinar in 2 months. But with respect to this document, the primary thing that you're typically doing is extracting from it the issue date and the patent number. You may also be pulling off of it the number of days for a patent term adjustment. Now, typically there's already a deadline on the on the docket for a continuation or divisional to be filed. But if that isn't on the docket, you would definitely want to make sure you're adding it at this point. But in terms of deadlines that are specifically tied to this document, there aren't any. It's just the bibliographic data for the issue date and the patent number and maybe the PTA that need to be updated in your system. And with simple documents like this, like we talked about on one earlier in this program, something like this can be 100% automated. These documents can be OCR'd, read, have those pieces of information extracted off of them and put into your docketing system. So let's go to the next slide. So after today's program, just a quick recap, you should be able to identify the common PTO documents that are associated with final rejections, appeals, and allowance, and understand what deadlines need to be docketed for those particular documents. And then I hope that we've also illustrated how automated docketing can be far superior to humans when it comes to actually identifying documents and conditions in documents that need to be docketed, and that in turn then reduces the manual errors associated with docketing. You know, in my experience, 80% of docketing errors are a result of some type of human error. So where you have a process that can be done more reliably by a machine, that is, you know, there's many advantages, and that is definitely the direction that the docketing processes are going. So at this point, we're over time. I'm not going to open it up to questions, but we will be providing these slides. And then Michelle, if you could just go to the contact slide, which I think is the next slide. No, I think it's the one after the slide, after the question slide. So if you want more information about the Schwegman-Lundberg firm, you can talk to Michelle, and her contact information is here. If you would like to learn more about Black Hills automated docketing and find out just what that could do for you, we'd be happy to talk to you. Please reach out to Jim Brophy. We have his email address here, or you can also go to the Black Hills website and fill out the contact us form, and we will set up a time to talk to you. So thank you very much for staying on through this long program. We had a lot to cover, and we did it quite well. Thank you very much to Z and to Adam for all their work on this program. And thank you everybody for joining another one of these. And I hope you'll join us in 2 months for the 4th one in this series. Have a great day, everybody.